Testing, testing. Okay, welcome to the Public Service Commission's administrative meeting for August 14th, 2024. First item is to approve the minutes of our meeting from August 7th, 2024. Commissioner Barbe.
Aye.
Commissioner Richard.
Aye.
I vote aye.
Good morning, Mr. Chair. The first item on today's agenda is on the consent agenda. It's PEG Bandwidth MD LLC and Unity National LLC's request for approval to participate in certain financing arrangements.
And with that, I move that we note the filing. Commissioner Barbe.
Aye.
Commissioner Richard.
Aye.
I vote aye.
The second item on today's agenda and the first item on the administrative agenda is from Delmarva Power and Light Company. It's revised tariff pages for an update to its retail transmission rates.
Hi, good morning. Good morning, Chair and Commissioners. This is Alessandro Lee on behalf of staff. On May 10th, 2024, Delmarva filed its 2024 annual formula update with FERC, which was incorporated into the PJM Open Access Transmission Tariff. The revised retail transmission rates were approved by FERC and went into effect on June 1st, 2024. The next day, July 2nd, or the month after July 2nd, 2024, Delmarva filed its revised retail transmission rates with the Commission for retail customers to be effective September 1st, 2024. The Delmarva formula rate for transmission costs is the sum of DPL's share in the Delmarva Zone Network Integration Transmission Service plus DPL's share of the Delmarva Zone's transmission enhancement charges minus the EL 05121 settlement adjustments. Under the revised rates, retail transmission rates are changing, residential transmission rates are changing between -6% and 27%. Type 1 rates are changing between -17% and 56%, and Type 2 rates are increasing by 6%. This increase in rates is primarily due to increases in the network integration transmission service subcomponents, namely true-up of actual plant to projected plant, increase in operations and maintenance costs, and increase in total other income tax. Staff recommends that the Commission accept the revised tariff pages for filing with an effective date of September 1st, 2024. Thank you, and I'm available for questions.
Any questions?
Just one. Thank you, Mr. Chair. When you say a noteworthy increase in the true-up amount, went from $4 million to $21 million, can you just give me a little more understanding of what that means? What drove that true-up?
Well, based on a response from the company, the way it was explained was that the true-up component in the annual transmission rate update is the true-up of the projected calendar year 2023 revenue requirement to actual calendar year 2023 revenues, which were received by PJM.
Okay. So there's not a budget. I can ask the company. So, all right. Thank you.
Thank you.
Okay.
Good morning, Mr. Chairman and Commissioners. Matthew Seegers, appearing on behalf of Delmarva Power. Appearing with me is Mr. Lance Schaefer, who is our subject matter expert on this. We appreciate staff's analysis. We have nothing to add. And Commissioner Richard, I'm going to bring up Mr. Schaefer to see if he can provide some more flavor
Appreciate that. Thank
in response to your question.
Mr. Chairman, Commissioners, good morning. My name is Lance Schaefer. I'm the manager of rate administration at PEPCO, and I should say PHI, so I'm here for DPL also. Yeah, regarding the true-up component, right? In all of these filings in the FERC wholesale filing, there's a forecasted amount that runs up until I believe May of the current year's filing, and so there is a true-up component the next year to true up the difference between the revenue requirements that were projected and the ones that actually were incurred, and so that is the difference between those. Between the filed in the previous year and then the filed this year, where we had the actual costs versus the actual revenues that came in.
Okay. So it's just it wasn't a cost necessarily in the projects or
Right.
that budget overruns or things like that.
Correct.
Okay. Because I'll have a similar question for the PEPCO filing as well. Okay, thank you.
Okay. Anything else? All right, well, with that, I move that we accept the tariff revisions for filing with an effective date of September 1, 2024. Commissioner Barbe.
Aye.
Commissioner Richard.
Aye.
I vote aye.
The third item on today's administrative agenda is from Potomac Electric Power Company. It's revised tariff pages to update its retail transmission rates.
Good morning, Mr. Chair and Commissioners. Eric Delgado on behalf of staff. On July 2nd, 2024, the Potomac Electric Power Company filed proposed tariff revisions to reflect its updated retail transmission rates for Commission approval. The updated retail transmission rates reflects PEPCO's 2024 formula rate filed with the Federal Energy Regulatory Commission, FERC. FERC permits utilities to recover transmission costs and transmission enhancements through what is known as the formula rates. FERC has approved PEPCO's formula rate and has been in effect since June 1st, 2024. PEPCO's formula rate for SOS transmission costs is updated annually and is passed through to customers. For the 2024 to 2025 rate year, retail transmission rates are increasing between 13 and 34% for residential customers. A PEPCO residential customer with an average monthly consumption of 824 kilowatt hours can expect a $4.19 increase in their monthly bill. The main driver for the increase in the retail transmission rates is the increase in the revenue requirement and PEPCO's FERC-approved formula rate. PEPCO's net zonal revenue requirement has increased by 31.46% since PEPCO's previous filing in 2023. The increase in the revenue requirement is primarily driven by significant transmission additions, which was forecasted to be $446 million in 2023, but resulted in $510 million in 2023. The transmission additions drove the increase in investment returns and the true-up amount, which accounts for the majority of the revenue requirement increase for the 2024 to 2025 rate year. Staff recommends the Commission accept PEPCO's proposed tariff revisions for filing with an effective date of September 1st, 2024.
Okay, so any questions for staff?
Good morning, Mr. Chairman, Commissioners. Still Matt Siegers. This I'm appearing for PEPCO. If you have any questions, we're available. We have nothing to add to staff's analysis, and we appreciate it.
Yeah, if I could, as I mentioned, just similar question. In this case, there was specifically this forecasted rate of 446 million, but it resulted in a 510 million transmission additions in 2023. Can you help me just understand what drove that difference between the 446 forecast to the 510 actual?
So I'm not sure I have all the details on the difference between that actual and that came in. The actual amounts that came in for the closing were simply different, higher, and then the associated revenue requirement with that increase is also what drove that. So the amounts that were forecasted versus the amounts that were approved were obviously approved by the FERC, found just and reasonable. So there were some costs that were simply, when they materialized, were simply different than the forecast there.
Okay. Yeah, I mean, it is FERC jurisdictional. However, we're going to see a lot of these costs coming. This is just the beginning, and so I mean, it's important for us to really be able to understand when we're seeing a forecast of a certain amount, and then it comes in $50 million more. I mean, especially given all the other projects that we know are coming our direction. So I think it's important that in future encounters like this, that we do have some better understanding or what's driving this, because while again it's FERC jurisdictional, we may need to also have staff go to FERC and start questioning some of these increases over forecasts. So.
Yeah, certainly, and we can always provide that. The filing that's done in May is publicly available, and we can. I know we've had discussions about this before, where we've turned back to the FERC proceeding, To the extent that, especially when staff is reviewing and asking SDRs if they want us to supply those documents, I mean, I know they're publicly available, and so they could get them without us, but we're happy to supply them also, and answer those questions leading up to this. No, that's totally understandable.
Okay, I appreciate that because again, I think since my time here, some of the various rate increases on the retail side have been below what you're proposing here today, as now going to be a monthly increase of over $4. So that is significant, and we know a lot more of these increases are coming from the transmission and the wholesale side. So I think it's going to be incumbent on us to fully understand what's happening.
Yeah, understand.
Appreciate it. Thank you. Thank you, Mr. Chair.
Okay, and with that, I move we accept the tariff provisions for filing with an effective date of September 1, 2024. Commissioner Barbe?
Aye.
Commissioner Richard?
Aye.
I vote aye.
Thank you.
Now, regarding the last item, we're going to do a couple things here. One, we're going to go into a confidential session, so anyone who doesn't have a specific interest in item number 4, I actually need you to leave the room. And then secondly, why don't we have everybody sort of come up to the front table here in the front row, because I assume there's going to be an extensive discussion, and that'll save people having to jump up and down to the podium. So,
Mr. Chairman, I think we've reached an agreement in that we are going to enter, at some point we will get into confidential information, and then we would go to confidentiality at that point. To the extent that there's non-confidential information.
Yeah, staff would object to beginning in a confidential mode. Well, we believe that at least my opening marks will not include confidential
all right.
information.
Okay.
Okay, I just want to make it easier for, so we're not jumping around with that, so. So I guess the floor is yours, so.
Ready to go?
Sure.
Good morning, Chair and Commissioners. Peter Wolson on behalf of staff in this matter. The Commission is very familiar with this case, which has been going on for about four years. So I will be very brief. Following our last hearing, which was on April 17th, the Commission confirmed Smart Energy's obligation to refund to its former customers those amounts ordered in Commission Order number 89795, which order was confirmed by the Supreme Court of Maryland, as well as every other appellate court in Maryland. Among other things, the Commission ordered Smart Energy to confirm its intention to satisfy this refund obligation in the letter order that followed the April 17th hearing. The Commission also encouraged the parties to meet to try to resolve the pending compliance issues, because at that point, and to this date, in fact, Smart Energy had not made any refunds, despite numerous Commission orders to the contrary. As to its refund obligation, Smart Energy conceded that it is approximately an unaudited amount of $15.97 million. But it failed to confirm that it has an intention to fully satisfy that obligation, stating that it only intends to satisfy its refund obligation as much as its balance sheet will allow. The parties did meet. We were unable to arrive at an agreement on compliance issues or find any way to settle this matter. And as a result, staff filed comments and amended comments which recommend that the Commission call the two Smart Energy bonds that total $2.75 million, order Smart Energy to satisfy its refund obligation to its customers within 30 days, as has been repeatedly ordered by the Commission, and to determine at the end of that period a civil penalty based on Smart Energy's fulfillment, vel non, of the refund obligation. On the day that staff filed its comments, Smart Energy filed a motion to modify the remedy in this case to an extent that apparently it believes would be allowed by its balance sheet. By this motion, Smart Energy seeks to bargain directly with the Commission to overlook its tens of thousands of adjudicated consumer violations and its 32,000 defaulted customers. This Commission has ordered that Smart Energy disgorge the illegal revenues of its pattern and practice of consumer violations as the Supreme Court of Maryland has approved. It would not be in the public interest, and it would simply be wrong to absolve Smart Energy of this obligation to disgorge its illegal profits for the economic expedience of keeping Smart Energy a viable business entity, which is what Smart Energy said it intends to do in its motion. OPC in its filing makes a good point. This proceeding should not be made into an accounting exercise. The ability to pay what is convenient to Smart Energy is not the standard for determining remedies for consumer violations, particularly when violations took place on the massive scale that they did here. Nor should threats of bankruptcy or further litigation be a factor in what the remedy remains. Staff stands by its recommendation that the Commission draw down both Smart Energy bonds and order refunds to be completed within 30 days, followed by further collection proceedings if necessary.
Okay, any questions for staff? All right. Office of People's Counsel.
Thank you, Your Honor. William Fields for the Office of People's Counsel. We agree entirely with all of what Mr. Wolfson just said on behalf of staff. I won't repeat all of that. The case has been going on for a long time, even up till the company's most recent filings. They're still trying to portray this as a legal question, and really not taking any responsibility for the pattern of deception of their marketing, the failure to follow basic contracting rules and the regulations that were there all along, like providing contract summaries, all of these things that give customers an opportunity to avoid offers that aren't in their best interest, which is what we saw here. The remedy amount that they've complained about here and elsewhere is a simple product of how many customers they were able to sign up through these deceptive marketing schemes and how much they charged above the utility price. It's really, no more complicated than that. The Commission hasn't even entertained or hasn't made any decision on any kind of civil penalty yet. So the remedy we're talking about and the dollar amounts are all just a factor of how many customers they were able to sign up through these methods and how much they overcharged them. And we, along with staff, certainly oppose any effort to reduce that. We are very wary of trying to come to a conclusion about the financial condition of this company. We made some comments. They're confidential part of our letter. I don't want to get into them right now. But, it's a very complicated thing to try to uncover all of the, transactions over years and financing agreements and what they all mean. And we shouldn't, I don't think we shouldn't do that. I don't think the Commission should do that. They have, they came to business. They came to Maryland to do business. They didn't follow the rules. They deceived people. They've been ordered to do refunds. I think that's as far as we need to go, and I think they need to be given a specific direction, because if we, continue to say, well, we'll talk about it, we'll negotiate, we just end up in this circle where we're back here, and now they're trying, as Mr. Wolfson said, they're trying to negotiate with you. I think it's time to put an end to that and to give them a direct order to do these, to provide these revenues by a date provide these refunds by a date certain, and put that obligation directly on them without any further discussions and negotiations. Be happy to answer any questions for the commission.
So, any questions for OPC? Okay, so who's going to take the lead for?
I am. Thank you, Mr. Chairman. For the record, H. Russell Frisbee Jr. on behalf of Smart Energy. With me, I have Brian Green and Doug Gansler, my co-counsel. Also present in the room is Dan Kern, who's the CEO of Smart Energy. A couple of points I'd like to make before I turn to Mr. Green and Mr. Gansler. First of all, we don't see this as bargaining with the commission or negotiating. Our position is that under the federal rules, we have the absolute right, when there's an impasse in negotiations, to present a solution to the actual judicial body, in terms of this case, the commission. So we think we do have the right, and we also believe that in making its determination, the commission does have the ability to examine various factors, including ability to pay, as well as really how this case came about. And I think those are important factors. As was mentioned, in this motion, we asked the commission to modify the remedy portions to provide that Smart Energy would make a payment of $3 million. That would be composed of three elements. First of all, Smart Energy put up $2.5 million cash bond. It's all in cash. There's another $250,000 bond and $250,000 from Smart Energy's balance sheet, which we'll get into the effect of that later. I believe this is a fair solution for a case that I think everybody admits has gone on too long. From Smart Energy's perspective, it's facing potential fines of 32 times anything the commission has ever levied in the past. The offer represents 6 times what anything the commission has levied in the past. And I think if you read the pleadings of both staff and OPC, they admit that what they're doing would put the company out of business. We submit, and I know they're going to disagree, that at heart this is a test case with regard to the Maryland Telephone Solicitation Act. And the question there was whether wet signature was required when a customer called a company, as opposed to the normal situation, which is the one that I think in the federal law and elsewhere, it only applies when the customer gets a cold call. We're talking about the 6 o'clock cold calls. This case, quite frankly, I believe at least, would not be here but for that, because if you look at what's happened with the commission, a number of other cases, all the other cases are settled for far less, even the cases with regard to the MTSA. It's only this one which is still outstanding. Now, as I mentioned, that there are certain factors I think the commission should take into account. Mr. Green will cover some of them, but and I'm only talking about what's in the record. In the record, before Judge Lawrence, who is I've tried cases against her, I know how good she is. She found that the MTSA did not apply decisively. She found it. Obviously, she found other things against the company, so she was clearly not necessarily a fan of ours. But she determined that the MTSA should not apply. Also, Smart Energy was not doing this as a lark. A year before the complaint was filed, it reached out to CAD, got a decision saying that a wet signature was not required. It was following CAD's directive. It did the right thing. It asked CAD. CAD told them. 5 days before the complaint was filed, again, there was a CAD decision on a specific Smart Energy case which said that wet signatures shouldn't apply. Then, 2 or 3 months after the complaint had been filed, another CAD decision saying that wet signatures were not required. And at the same time this complaint was filed, the commission website said that wet signatures were not required. Also in the record is that if you look at the welcome letter and the materials that were sent to the customer, they got all the material information. Now, yes, there was a mistake. There was a mistake in that the summaries were not sent. But as soon as Smart Energy found out about that, it did send the summaries. Again, that's in the record. Also is in the record that there was complaints about the script. That was changed. So they hired Mr. Green and got rid of their New York lawyers, and the script was improved. Also, a sensitive monitoring system was also put into place. And I could go on, but a lot of the complaints were dealt with, and that should be taken into account. And finally, let's think about this. We're talking about 34 complaints out of 32,000 customers. 34 complaints. This company did not even make Chairman Stanik's, I guess he called it the complaint scorecard, even once. But a lot of the companies where they did settle, who did far more than anything that Smart Energy was alleged to have done, and had the same type of MTSA violations, settled for far less. So I guess our feeling is that everybody fought hard on the MTSA. It was a very unique question, first time in Maryland. Maryland differs obviously from other states. We lost. The commission won. The commission wanted to get a precedent, a judicial precedent. It's got it. It's time for everybody to go home and arrange a settlement that works for everybody, because what they're also not saying is that one of the things that would happen if the commission adopted the $3 million settlement is that that's the only way you can guarantee that the consumers get a maximum. I mean, if it goes to other courts, bankruptcy, et cetera, who knows what could happen? It could tie up for years, and everybody could end up getting nothing. So that's why we believe it's fair. With the commission's permission, I would turn it over to Mr. Green and also invite Mr. Kern to the table, because obviously I know you want to hear something about the company and finances. And Your Honor, at this point, I would ask that we go into confidential session, because Mr. Green is going to talk about confidential information, which even has been marked as confidential in the pleadings filed by the staff and OPC.
Okay.
Your Honor, I would object to a couple of things. I would object to going into confidential session at this point, because I think, well, first of all, I would object to a series of attorneys doing presentations when parties are typically represented by one attorney, and here we have 3 competent attorneys. But I would also like the opportunity to respond to Mr. Frisbee before we move on, if we are in fact going to move on to other attorneys. And also I would make an objection on relevance as to financials of the company. The financials of the company have no bearing whatsoever on the reduction of the remedy that has been levied and approved by court after court in this state.
All right, so I think actually we will go into confidential session just because I'm, I don't want to, once that bell's rung, I can't unring it, so. And as far as the response, my plan is to go ahead and let Smart Energy make its presentations to us, and then I am going to circle back to both you and Mr. Fields to get your responses and reactions to anything you've heard from them. It's our intent, even though we're not going to issue a decision today, to actually, start the process of bringing the curtain down on this show. Now, I am aware of the fact that apparently Smart Energy is considering seeking, relief from the federal courts. So maybe our goal of bringing the curtain down won't happen, but at least we'll try and take a step in that direction. So we are in confidential session, and